I'm Jonathan Ochshorn. This is part 5 of a series of lectures dealing with health, safety, and welfare in buildings, and how those aspects of functionality or utility can be constrained by politics and economics and damaged by expression. Part 5 deals with the politics and expression of accessibility. So, accessibility, and just like a really quick overview of attitudes towards disabled people. Early attitudes, let's say pre-19th century, tended to have a kind of moralistic benevolence. So handicapped citizens are considered to be part of the so-called deserving poor, and there are various charitable agencies or religious entities that would somehow deal with this issue as it occurred. This changed in the 19th century to some extent, where you started getting more of that Thomas Hobbesian type of attitude, a liberal individualistic culture. And in that kind of a cultural context, disabled people were considered to be unable to compete and therefore spurned by society. This changed to some extent in the early 20th century, triggered a lot by the First World War and also by the growth of industry. And both of those things triggered lots of injuries and accidents and created thousands and thousands of disabled people as a result of industrial accidents and war accidents. And this changed the logic underlying remediation. So you started getting organizations that were lobbying for a different attitude towards disabled. And it had to do a lot with a kind of a self-serving attitude that this is something that needs to happen in order to give people confidence that if they go to war, which is a never-ending function of modern societies, that if they get injured, they'll be taken care of. And the same goes with industrial injuries. Fast forward to 1961, the first instance of the ANSI 117.1, ANSI being the American National Standards Institute, and that's what they do, they make standards. And this was one of their important standards. It's still with us. Every few years it gets updated. The picture is from 2017, for example, but it originated in 1961, and it was a standard for accessible and usable buildings and facilities. It had no legal status. It's just a standard, free floating out there. If you're interested in making buildings accessible to people with various disabilities, it's a really excellent place to look. It gives you lots of guidelines. But the requirements were voluntary, and from the standpoint of architecture, they're generally ignored. Architects have this kind of attitude about freedom, and any constraint on freedom is felt to be something that they don't want to deal with. Another important landmark in this quest for accessibility, that is making buildings usable by people with various disabilities, comes about in 1964, and this is the Civil Rights Act, which didn't do a thing for disabled people, but it created a template for what might be done. So it puts ideas in people's heads that, yeah, maybe people have rights. So even though this particular act didn't deal with this disability, it was still an important landmark. Then you start getting incremental federal and state regulations and legislation. For example, the federal government decided to create a law requiring that federal buildings be accessible. It's a tiny subset of the built environment, and yet if you're building a federal building, it must be accessible. And various states on their own made disability guidelines, but there was no national law until 1990. And this is the most important piece of legislation that deals with accessibility. It's the ADA, or the Americans with Disabilities Act. So this is George H.W. Bush signs it into law 1990. And it mandated access, not immediately. It took a few years before the architectural barriers, so-called, had part of it was implemented. But nevertheless, it required all new construction to be accessible. But more interesting, since most buildings in the world are not new, they're already there, it required US buildings, whether or not they were new or existing, to upgrade themselves and become accessible. This is very unusual. Building codes in general don't have the requirement that every time there's a 3-year upgrade to the building code, that every building in the country has to upgrade their facilities. No, if you were legal under the code under which you were built, in general, you can stay that way. It's called being grandfathered. So it's very unusual for a law to act retroactively on existing structures. It happens occasionally, like if you're from California, you know that old masonry buildings, even if they were legal when built, have to upgrade to seismic requirements, for example. So it does happen, but it is unusual. And this was one of the bills that was unusual in that respect. However, and here's where the politics comes in and the economics, there was still a cost-benefit logic to how you would apply this requirement. And it turns out that there were a couple of ways that were, a couple of things that were deliberately put into this law that made it more difficult to actually enforce this requirement for existing buildings. For new buildings, really not an issue, because if you're building from scratch, it's pretty easy to accommodate these requirements. So these are two of the Congress people. Dale Bumpers was in the Senate, Steve Bartlett in the House of Representatives at the time. And these are some quotes that indicate that they have a very modern attitude towards the topic. That is, they recognize that this is useful, important, maybe even necessary, but they also recognize that there's a kind of a cost-benefit logic to it, and that you can't really, or from their standpoint, you can't really make everybody upgrade their building. It would be, in some cases, impractical, in some cases, too expensive. And in cases of, let's say, historic buildings like Sibley Hall, you might not want to fiddle with the historic facade. And so there were all sorts of exceptions and things that were built in. This is what Dale Bumpers says: we are obligated here to weigh the interest, that's that balance, right? I'm not making this up. Weigh the interest of the rights of the handicapped, which ought to be total, against what is obviously going to be quite a burden for a lot of small business people. So, you know, they're saying, yeah, we should do this, but maybe we shouldn't do it to the extent that would actually remediate all the problems. So they built into this law the so-called undue burden clause. Let's just read it. Undue burden is a requirement of Title II or Title III. These are sections of the Americans with Disabilities Act, only one of which affects architecture. You know, there's a lot of other parts of the act that affect, let's say, your right to employment and stuff like that. It's a requirement that would cause a significant difficulty or expense if carried out. This means that a state or local government or its agencies or a business or nonprofit organization covered by the ADA does not have to provide an auxiliary aid or service or a modification if providing it would cause a significant administrative or financial difficulty. So again, it's saying, yes, you must do it, except if you just claim that it's too hard, then you don't have to do it. And there's no enforcement mechanism in this law. It's not like they have men in black going around inspecting every building and putting people in prison or fining them if they discover that a building is not accessible. There is no enforcement. The only way that you can get somebody to make their building accessible if they are claiming that they can't do it because it's just too hard or too expensive, the only way you can get them to do it is to sue them. So it's left to the individuals who may encounter something and then say, this is not right, I'm going to sue you. And then it goes to court and the judge will decide whether or not this was a significant difficulty. There was this interesting article recently in the New York Times about a man who filed more than 180 disability lawsuits. Most businesses will pay thousands of dollars to fix their bathrooms or install wheelchair ramps, not because it's the right thing to do, but because they could be sued for many thousands of dollars more for not having done it. Quote, this is a law that exists in the heavens, this scholar of disability studies told me. It doesn't work unless you bring a lawsuit. There's something called injunctive relief, which is what the law allows. This means that if you sue somebody under the ADA, and let's say you win, what winning means is that they have to fix it. And it turns out that that is a disincentive to file a lawsuit. I don't know if you watch like television where you get the lawyers that come on television and they say there's no cost to you unless we win. they can do that because it's not injunctive relief. In other words, they can do it because there are penalties and they can get money for damages and for all sorts of things and legal fees. And in other words, they can make a lot of money by suing, but you can't make a lot of money by suing in the ADA because it's specifically limited to the so-called injunctive relief. So that's another thing deliberately put in the law to make it harder to bring lawsuits. The reason that the New York Times articles had this guy suing 180 times is because I think mainly he was doing it in California, and some individual states allow damages and other kinds of compensation. So in certain states, lawyers can do it on a speculative basis. In any case, these are some of the political things that happen to make it harder to actually enforce the ADA. We'll talk about mainstreaming. This is a newer concept. It didn't appear in the original 1961 ANSI standard, but it's becoming more important, and it shows up in the latest building codes. The building codes have not exactly incorporated the ANSI standards into the building codes. They're already sort of incorporated into the ADA. So ANSI is just a freestanding standard, but everybody has kind of incorporated its guidelines. The ADA has, which is a federal law, and then the building code has also taken upon itself to put accessibility guidelines in the code. And they pretty much coincide with the ADA guidelines. They're sort of the same. And in the building code, they're now talking about this concept of mainstreaming, designing buildings with consideration of accessibility for all people, not just those with disabilities. And the idea is that people with disabilities shouldn't be singled out. And in that respect, the classic instance of singling out non-mainstreaming disabled people are the grand entrances with monumental stairs. This is obviously problematic if you have a disability where you can't walk up a stair, but it's also problematic if you somehow retrofit the building where you go around the back or some side entrance and you say, okay, we'll make an accessible entrance for you, but you're treated differently. You're not mainstreamed. And the latest state-of-the-art notions of disability and accessibility is that you shouldn't just allow disabled people to have access, which is a requirement, but you should also think of it in terms of integrating all people with the way your building has been designed. We'll take a look at that. I'm going to look at some monumental stairs and then other objects that protrude into circulation paths, which is a real problem, especially if you have a vision disability. So this is the Supreme Court building, ironically, a monumentally inaccessible building. Of course, there's a way in if you're disabled. It's presumably not up the stairs, but somewhere around the back. So it's a classic instance of this arrogance of monumentality, and it does not allow disabled people to feel like they are being treated in an equal manner. Here at Cornell, there are instances where architectural expression has compromised this notion of mainstreaming. You recognize this building by Coder Kim Associates, the physical science building. Physical sciences building at Cornell sits on top of a hill. So someone in a wheelchair would need to take the ramped path rather than the stairs placed on axis to the main entrance. Once at the entrance, one notices that there are more stairs directly inside the vestibule and a sign pointing to accessible elevators to the right. The elevators would be impossible to find except by following a series of signs. This is not exactly a direct route. The path turns towards a door and there's an automatic door opener that one can use, at least in principle. It wasn't working. So I opened the door manually. Once inside, there's a second door, but this time the automatic opener works. We enter into a rather uninviting corridor with a small sign indicating that elevators are to the right. It's hardly evident where the elevators are. Where are the elevators? I turn left down another corridor and finally come to the accessible elevators. Now, this is the opposite of a building design that incorporates the concept of mainstreaming. The building's notion of architectural expression instead relies on a series of indoor and outdoor stairways that exclude people in wheelchairs or people with other disabilities. And we're going to be coming back to this stair, so keep it in mind. The second thing, now that we've dispensed with monumental stairs, I think it's self-evident that they are problematic. Even if you have some other means of accommodating disabled people, it's problematic from the standpoint of mainstreaming. This is a huge issue in architecture to this day, which are required limits on protruding objects. This is a term used in the ADA, in the building code, and in the ANSI standard 117.1. And the idea is that if you have a vision disability and you're walking with a cane, you can detect objects that might get in your way within the sweep of the cane. But if there's an object that's a little bit too high, your cane isn't going to find it, and you can collide with it. So that the rule is, if you're for any circulation path, which is any place where a person can move, in this room right here, anywhere you can basically walk, you can't have things sticking out of a wall more than 4 inches. If they are above the sort of cane sweep zone, which is 27 inches. So if it's above 27 inches, the cane won't find it, so you can only stick something out 4 inches. And that's what this is showing here. If the object is more than 4 inches, but goes down under that 27-inch limit, then it's fine, because your cane will discover it. It won't present a hazard. And similarly, if you're above this 80-inch mark, you can do whatever you want. The presumption is that if you're 80 inches tall, well, you've got all sorts of problems, and we're not going to deal with you. This is the rule for protruding objects, and it's just constantly violated by architects. In fact, in that very stairway in the physical science building, there is this expressive kind of angled wall that creates a soffit. That's like a ceiling that's indoors, right? So if you're, let's say, vision impaired, and you're walking up or down the stair, this is an egress stair, by the way, not just a but it doesn't matter. It's a circulation stair. If you hold the handrail, you will then crash your head into that soffit, because it's leading you directly into this protruding object that is completely in violation of the building code, the ADA, ANSI standards. Somehow the architects designed it this way, and the building department allowed it. Nobody saw it. And in fact, I've walked up that stair hundreds of times, and I never noticed it either. So it's just one of these bizarre things. The reason I know about it is because of a student in my building technology class back in September 2018, and I did my little lecture on accessibility and protruding objects, and he sent me this image on the left. And he says, "This can't be right, can it?" And I said, "Whoa, let me go check this out." So that's the next image. I went and checked it out, and I said, "Yeah, this is not right." So for the next year, I sent multiple emails to Cornell facilities people and saying, this is, and the building department, saying, you've permitted this building and it's non-compliant, it's dangerous, it needs to be remedied, and nothing happened. So finally, like a year later, I opened my Photoshop, and I took the railing, which is where the shadow is, and I just bent it a little bit using Photoshop. I sent the sketch and said, "Look, it's not rocket science. If you take the handrail away from the wall, then nobody will bump into that soffit, and everything will be fine." And shortly thereafter, I was walking, and I discovered, whoa, they actually fixed it. So it took a year and a half, but they fixed it. And what you can see is that, remarkably, this is a completely gratuitous and silly thing to do, but architects sometimes get so hung up on these modes of expression that they lose sight of the functionality of their buildings. Oh, and this happened in Milstein Hall in like 1,000 different places. So this is how Milstein Hall was originally built and got its permit and was occupied. And it had sloping walls, sloping columns. And as you're well aware, since you live in this building. And all of these things are completely illegal, dangerous, and in violation of the building code and the ADA and the ANSI standards. And once again, as a good citizen, I emailed the facilities people, the building department, the project managers, and said, you're in violation of the code. And so they acknowledged that, yes, I'm right. After the building was occupied, they put in these cane guards or cane detection guards, which are, in my mind, really kind of stupid, to use the technical term, and also dangerous, because you can kind of trip over these things too if you're, let's say, escaping in a panic or in a fire. But they become necessary because of the completely gratuitous bending and of these walls. The sloping of these walls, even this entire column, is completely unnecessary and gratuitous. I interviewed the structural engineer because I was making a construction video on the dome. And I said, so you must have needed this column to hold up, it's right behind the auditorium, to hold up the weight of the auditorium, right? And the structural engineer who designed the concrete said, oh no, we didn't care about the column. Actually, the architects put that into their model, so we just incorporated it into our model. It was completely unnecessary. The dome would have worked perfectly well without the column, but the architects simply wanted it there.